going to go ahead and get started. I'm Faye Barron. I'm with Human Resources. Thank you all so much for being here today. We have Janine Newcomer here today with us from UK Federal Credit Union. Janine is a business development specialist with the UK Federal Credit Union. The business development team specialize in providing financial education solutions for employers and the community by delivering expert-led sessions like this one, tailored to meet the needs of today's employees, covering everything from budgeting to estate planning. UK Federal Credit Union believes that financial wellness is a critical part of overall employee well-being. Here to share more about the credit union and to introduce our speakers, please welcome Janine Newcomer.
Hello. Hi. So welcome. Thanks for taking some time to invest in yourselves and in your family. So it's really, really important. Can you all hear me? Okay, perfect. Do we have any existing members in here already with UK Credit Union? Yes. Perfect. Love it. Thank you for being a member. If you're not a member, we will be sitting back here to the side at the end. So we reserved 30 minutes. If you've got questions about becoming a member, if you want to become a member, to join, it's only $5. We have our iPads, and it takes less than 5 minutes to get started. So just know that's available for you. We're trying to make it as easy as possible. So some things that are going on. Does anybody know the difference between a credit union and a bank? Anybody? So you do? Awesome. Okay. So we are not for profit. So any profits that we get, we turn back into the community, lunch and learns, financial education, scholarships. So that's what makes us a little more different than a bank. So all of our board members are volunteers, so they don't get paid. So they make those decisions based on what's best for our members rather than clients, right? So that's what makes us a little different and a little special. We were founded through the University of Kentucky College of Agriculture 87 years ago. So they are our legacy partner. So just welcome. Thank you for attending. Enjoy your lunch. With that, I'm going to turn it over to these subject matter experts. So we've got Alex Brown. He's an investment provider with us. And then we also have Connor. Can you go back? Yes. Sorry, Connor. I skipped over you. He is with Rose, Kaminish, Stewart, and Maines. So he is the subject matter expert for estate planning. So at the end of this 30 minutes, if you have a question, feel free to raise your hand. If it's something you want to talk to these folks one-on-one afterwards, you're more than welcome to do that. So we set some time aside for you all. So with that, enjoy.
Alrighty, my name is Alex Brown. I'm a financial advisor at UK Credit Union. We'll go ahead and get started on this. I will say that we were asked if you had a question that you ask it into the microphone because this is being recorded, so she'll walk it over to you. And let's get started. So just kind of going over an overview here, just the basics of estate planning documents. We'll kind of go over that. We're going to go over probate avoidance measures, some trust planning, and just general advice I have throughout and how it relates to financial planning, retirement planning, things of that nature. So just to highlight some important documents you need. Now, Connor will go into these in a lot more detail. So power of attorney, designation of healthcare surrogate, living will directive, and last will and testament. And so with that, I'm probably going to turn it on over to him, and he'll kind of expand on all of these points.
Hi, good afternoon, everyone. Just the subject you want to hear about, estate planning, but it is important, and it's important that we plan ahead. That's for your sake and for your family's sake. We're going to talk first about several documents that operate during your lifetime, the first of which is a durable power of attorney. A general durable power of attorney is a document that basically helps to facilitate the operation of anything with a financial component that you may deal with. Maybe that's opening and closing bank accounts with the credit union. Maybe that's operating a business. Maybe that's paying taxes, making gifts, receiving gifts. A general durable power of attorney is a document by which you name someone to act as your agent. They are called your attorney in fact, and they can stand in your shoes, operate in your place to accomplish any of these financial goals or business that needs to be done. There are two ways that you can have a general durable power of attorney. One is effective immediately. The other is what's called a springing power of attorney, and it only becomes effective upon your being disabled. It's our general recommendation that you have a general durable power of attorney that is effective immediately, because if there is a circumstance where you become disabled, then there is likely a process that you would have to go through in order to have your attorney in fact obtain the power to act on your behalf. So if you can short circuit that process by having them serve effective immediately, then they can already do that. If you later become disabled, you don't have to then go through a process obtaining doctor's approval that you lack the capacity to make your own financial decisions. The other thing that's important is that you name someone trustworthy. For a lot of people, that's their spouse or their children. We understand that not everybody has spouses and children, so maybe it's a trusted friend, maybe it's a sibling. Some people who are younger have living parents, maybe it's a parent. It's someone that you would trust to handle your finances if you cannot do so. The next document that operates during your lifetime is a designation of a healthcare surrogate and HIPAA authorization. Some people might know that as a healthcare power of attorney. As long as you have the decisional capacity to make your own medical decisions, you're going to be the one making those medical decisions. But what if? What if you're unconscious? What if you're in a coma? What if, for some reason or another, you're unable to consent to a medical procedure, administration of some medicine, consenting to some surgery? At that point, if you lack the ability to do so, the person you name as your healthcare surrogate will be able to make that decision for you. Once again, it's important to name someone that is trustworthy, that you're comfortable with handling your medical decision making and comfortable with having access to your private health information. A lot of times we ask clients when we meet with them if there is someone in their family or in their close community that might work in healthcare. Generally, these people are better suited to serve in this role if so. It's someone that you want to be level-headed, that wouldn't panic in an urgent situation and would be able to handle making these perhaps uncomfortable decisions in short notice. And once again, this is important for the power of attorney as well as for any of these documents. Inform the people whom they affect that you have them. For the power of attorney, inform your financial institutions that you have them. Maybe give them a copy of them so that they can keep it on file with your accounts there. For your healthcare power of attorney, your designation of healthcare surrogate, the same advice rings true. Provide your medical providers with a copy of this document so that they can have it on their file in your charts with them if it's ever needed. The next document that operates during your lifetime is a living will declaration. If your doctors, your medical providers have determined that you are terminally ill, that you have no brain function, and that you would not live without the use of life support, artificial hydration, artificial nutrition, artificial ventilation, that's feeding tubes, IV fluids, and ventilators. This document is the document that allows the withdrawal of those artificial mechanisms if you want to not have the life-prolonging treatment. What we see a lot of times now is that people don't want to put the pressure on their family members to make that decision. It's an uncomfortable decision when to, quote unquote, pull the plug. People don't want to have to make that decision. This document states what your wishes are and allows you to direct the withdrawal of those life-prolonging treatments if you so choose. It also has the document as we prepare it has a selection about organ donation. It allows you to make a selection if you would like to donate your organs for transplantation purposes or for research. So those documents are ones that operate during your lifetime. The next document is one that operates at your death and only at your death. It's your last will and testament. How many, by show of hands, people have an existing will? Good, several. So studies have told us that only about 60% of Americans have a will. The alternative to a will is a process called intestacy. If you die without a will, a statute passed by the legislature determines how your assets pass to your beneficiaries at your death. Remarkably, if you die intestate and your assets are passed through the laws of intestacy, only 50% of everything you have goes to your spouse. The other 50% goes to your children if you have them, or to your parents, siblings, nieces, and on down the line. So for a lot of people, they want to direct how their assets should pass. A lot of people prefer that their assets pass through their bloodline. A will is your opportunity to direct exactly to whom it goes and how it goes to them. Consider this. Maybe you have minor children. You probably don't want those children coming into a large sum of money at the day they turn 18. Well, a will can include language holding those assets for them for a period of time until you direct when they should take possession of those. The other thing that a will does is it appoints your personal representative, the person who is in control of your estate when you die. That person is known as an executor. That's the person that basically stands in your shoes to coordinate the process after you die. The process of passing your assets through to your beneficiaries. Sure, all of you know what probate is or have heard what probate is. A lot of people are scared of it. It doesn't have to be scary, but having a will does reduce probate costs, because if you have remote beneficiaries and you have to track them down through the laws of intestacy and find them, that increases a financial obligation in order to do that. Having a will makes it clear. Once again, if you have minor children, the will is the document by which you name a guardian. So if you die and there's no one left to take care of your minor children, you can direct who that person is or who those persons are in the terms of your will. If not, it defaults to statute. People generally would rather make their own decisions than let someone in Frankfurt make those decisions for them. Now, it's not a case-by-case basis if that's, if it defaults to the laws of intestacy, but people generally like to have a say in their assets and their families. So a little bit more about what is probate. Probate is the court process by which anything you own individually in your name passes to your beneficiaries out of your name at your death. There are ways to avoid it, and a lot of people like to. The personal representative, the executor that I mentioned a minute ago, is the person that sees through that process. They will be the one who is appointed by the court to serve as basically the manager of your estate. They will pay the debts that need to be paid. If there are claims against your estate, they'll make the distributions to the beneficiaries when it's time to do so. The probate process also establishes the formal approval of the estate administration. That's the going to court before the judge, opening the estate, probating your will, and appointing the personal representative. Let me go back just for a second and say this. The probate process can be daunting, but it doesn't have to be. Nevertheless, people like to avoid it. Here's why people like to avoid it. It can be a little time-consuming. So when you die and your will is probated, then you have to file an inventory shortly thereafter, 60 days after the appointment of the executor and the probate of the will, the opening of the estate. You have to file an inventory of everything that you owned individually at the time of your death. That's in the public record. That's in the court's record. People generally don't like that private information to be there. At that point also starts a clock for a 6-month claims period. Can't be waived. It has to stay open for the entirety of the 6 months. This is an opportunity for any creditors to make claims against your estate. Maybe it's medical debt from your last illness. Maybe it's consumer debt, whatever the case may be. If a creditor makes a claim against your estate, after that claims period ends, those creditors get paid first before any of the distributions are made. So it drags it out a little bit. It doesn't always have to be long. Sometimes a fairly simple probate can be completed start to finish in 12, 15, 18 months. Sometimes they drag out much longer, especially if beneficiaries quibble or if it's unclear how it should pass. Alex.
Before I continue on, we just covered a lot of information. Any questions? Okay, well, we'll continue on here. So easy ways to avoid probate, joint titling of assets. So a really easy example for you would be a checking account. If you have that checking account labeled as joint, I mean, I can speak on how that works for the credit union. Before I got into financial advising, I was opening checking accounts. If you walk in, your spouse has passed, you bring in that death certificate. By the time you walk out, it's all done pretty quickly. That account now is individually in your name. So the pretty straightforward process there. Use beneficiary designations. Again, just using that same example of what I've experienced and when people come into the credit union, if you have those beneficiary designations, if it's something as simple as just a savings account or checking account we have access to right there, that beneficiary can be walking out that same afternoon with a check made payable to them. It'll be much more straightforward, much more quick, easy to take care of. One thing I will say with beneficiary designations, we actually ran into this in the last presentation. Check who your beneficiaries are. I've had this personal experience with me as well, where I had a client who called in and was wanting to update beneficiaries and did not realize that on her 403B at the University of Kentucky, her ex-husband was the beneficiary on that account. And someone actually had that experience shared with us on our last presentation. So check those beneficiaries, make sure they still apply. It's who you actually want to be on there. Sometimes people set it and forget it, and then 30 years later don't realize it's not someone they want to be on there. Consider transfer on death or payable on death designation where appropriate. You can see transfer on death and payable on death really generally mean the same thing, where we're just talking about making a beneficiary there. So how to adjust, so how to go through updating beneficiaries. You know, with your 401k or pension plan, whatever you have, there might be an app you can go on or a portal. You can just go in there and update it. Some might require paperwork depending on where it is, but usually should be a pretty straightforward process. And these days, you probably don't really have to go anywhere. You can sign everything electronically. So really look into that. Try to make sure you're getting on top of that. When you have a beneficiaries, sometimes people like to just default to the estate as a beneficiary. There can be kind of wrinkles to that and issues with that. So when I talk about issues, one thing I'm talking about is, say you have a traditional IRA that you've been saving for, and the beneficiary for that is your spouse. If you were to pass away and they take that inherited traditional IRA, they have the option to put it in their name and assume ownership of that IRA. So now RMD rules, just the regular tax implications of that, just follow their age, makes it a little more straightforward. If it's left to someone other than your spouse, the general rule there is you do have to liquidate that account within 10 years. So you have a 10-year time frame. If your parent passes away and you inherit a pre-tax, a traditional IRA account or a 401k of some sort, you have 10 years to liquidate that account. There can be some other rules on that as well, but generally 10 years. If you leave it to the estate, that can speed up that process. Instead of 10 years, you might just have 5 years. So be careful. That's why it's good to go in there and make sure you're naming someone who you actually want to be a beneficiary on there. And don't let...
The other thing is that it exposes, I'm sorry, I didn't mean to interrupt, but it also exposes it to creditor claims. So if you leave the estate as the beneficiary on any of your, retirement accounts, it would then pass through to the estate before it would pass along to your ultimate beneficiary. So if there were claims against your estate, if your estate did have debts, those monies would be subject to payment of those debts before they passed along. So you can short circuit that process by giving it straight to the beneficiaries.
Last thing I want to touch on with this, you can see here we're just talking about adding joint owners, making sure you have those beneficiary designations on any individual accounts you have to help you avoid probate. One other important thing that's good for having that beneficiary in there, and something that comes up a lot when you inherit something, is what's called a stepped up cost basis. So what that means is that when you inherit an asset, you get a stepped up cost basis. So let's talk about that with, let's say it's Apple stock. Let's say when you bought it, it was worth $10. I don't know what the price is today, but let's say it's gone up 10 times in price. It's worth $100 at the date of your death. If you had gifted that stock before you died to someone else, or just passed along ownership to your son or daughter, then they sold that stock, they would have to realize the $90 in gain from $10 to $100 and then pay taxes on that capital gains. If you leave it to them, they're a beneficiary on the account and they inherit it, you step up that cost basis. So if it's worth $100 per share when you die. That's now their cost basis when they inherit it. So if they go to sell that, there is no capital gains tax because they're selling it at cost essentially there. So that is something to keep in mind. Sometimes you might hear people say, well, I want to make sure I give these assets directly to who I want them to go to. So you're going to do that while you're alive. And there can be tax implications there that maybe you weren't aware of. And passing them on to the beneficiary might be more beneficial for you.
I'll say this too. A lot of people want to pass their real estate to their children during their lifetime as well, for the purpose of avoiding Medicaid's reach if they subsequently have to go into a nursing home. Here, the basis adjustment, the stepped up cost basis explanation is the same reason why that's not a good idea for real estate. There are ways that we can protect real estate from Medicaid's reach. Happy to talk more about that. It's in an irrevocable trust, an asset protection trust. It's a trust that you can't be in control of. You can't be the beneficiary of it. You can't be the trustee of it. It has to be someone else. You transfer your property into it. What Medicaid does is it looks back 5 years from the date you apply for Medicaid eligibility if you have to go into a long-term skilled nursing care. They look to see what you've done with your assets during that 5-year period. If you've transfer them out of your name in that 5-year period, they can still attach to them. But if you make it that entire 5 years, then they lose their ability to access those assets, whether it's real property or investment accounts, whatever the case may be. A lot of people think, oh, well, if I just give it to my children now and then wait the 5 years, for Medicaid purposes, the box is checked. They've avoided Medicaid's reach. However, those children have taken it at the parents' cost basis. They get a carryover basis instead of that stepped up basis adjustment. So that's why that's generally not a good idea. And we advise people to do the irrevocable trust planning instead. However, the flip side of that coin is that a lot of people don't want to relinquish control of their assets because they're still using them. They're still in the home and they don't want to risk the trustee selling it out from under them. Now, most people know that their children wouldn't do that, or whomever they would name as trustee wouldn't do that, but the fact of the matter is the trustee could. So for as long as they like to, people like to keep that control. Most of the time, people don't go into the nursing home until they're about age 80. So we start doing this type of planning for people when they're 73, 75. Circumstances may dictate, differently, but that's our general advice when it comes to Medicaid asset protection trusts. If you want to talk more about that privately, given your situation, I'm happy to do so. I don't know that we need to go through these in much more detail than what Alex already has. Jointly titling assets immediately avoids the probate process at the first spouse to die. If you have your assets jointly, then it automatically becomes the property of the surviving spouse, and you've avoided probate. If you die simultaneously, you're going to have a probate issue anyway, unless you use a trust or something else to transfer your assets out of your names individually. That's an easy way to avoid probate, at least at the first death. This note just a second ago said, don't forget vehicles. That's one of the things that we have to open probate for more than anything else. People have accomplished the goal of avoiding probate except for the vehicles. So you have to go to the county clerk's office. It's closer for you all than it is for a lot of folks. But you have to go take the title, both spouses or whomever you would want to name as a joint owner. Typically advise not naming children unless the circumstance requires it, because at the death of the first person to die, it automatically becomes the property entirely of the surviving owner, whether that's a spouse, a child, or whomever. I think Alex has adequately addressed this. I would say that it's important to not just have the primary beneficiary, but also the contingent beneficiary. Otherwise, it would default to the estate. So make sure you're keeping up with those. It's a good idea to check your beneficiaries regularly anyway. We advise people to talk with their financial advisors and make sure that whomever they may have life insurance with, to change, at least check those beneficiaries fairly regularly to make sure that there isn't an update needed. Family situations change, people pass away. There are myriad issues that happen in families that happen in every family that we can't forecast. So it's good take watch of those every now and again to make sure no update is needed. Yeah, I think Alex has addressed what TOD and PODs are. Back to you, I think, right?
So talk a little bit about the process of the transfer of accounts. I already kind of talked a little bit, just to start with, about that 10-year rule when you inherit it if you're non-spousal. And then if you are, this is for pre-tax IRAs or Roth IRAs that I'm talking about here, where that 10-year rule would apply. And then if it's spousal, you can assume ownership there and take withdrawals as you normally would. One thing I do want to touch on for beneficiary experiences when you're setting up a beneficiary, I think one thing that's also often overlooked is the different processes that you're going to get with each institution. Having come from a very, very small credit union before I started working at UK Federal Credit Union, the legal expertise is going to vary widely at these local institutions, especially if you're getting really small ones. Maybe they don't have the knowledge or the processes are a little antiquated. Just a personal aside, I know that for a family member of mine, one of the banks they had in the state that they had lived in 10 years ago required that we drive about 6 hours to go see them in person to close out everything. So one thing I would also recommend you do is if you do have assets in various places, maybe get familiar with the process there. You know, we're talking generally how everything works, but when you go and practically see what that means, it can be maybe a little bit more cumbersome, or there could be other requirements by that particular institution that you wouldn't have expected, and that might key you in to say, oh, I should consolidate, or maybe that's not the best, in my best interest to keep that account because it's going to cause a lot of burden to anyone I'm trying to leave money to. Roth accounts, transfer at death. Again, there's that 10-year rule we talked about for non-spousal. Those apply as well.
Okay. So what some people like to do instead of just having the basic will or having the default, which is intestacy, is a revocable living trust. This is a trust agreement that is created. It operates during your lifetime and at your death. You can direct funds to it to pass through your trust at your death to your beneficiaries. Retirement accounts can't go in a trust. They're qualified accounts. We can name the trust as a beneficiary of those accounts. There might be some income tax implications of that, but that's because of the Secure Act, which requires those withdrawals within 10 years for inherited qualified accounts like IRAs, 401ks. Otherwise, understanding when is a trust, when do you need a trust? Why would you need a trust? It's not necessary for everyone. I think there's a large push that everyone has a trust these days, and certain circumstances just don't warrant having a trust. Here's some things to keep in mind. Do you have assets that cannot be placed or that cannot be given a beneficiary designation? The big one is real estate. In Kentucky, you cannot list a beneficiary designation on real estate. The state of Ohio, you can, just as an aside, but in Kentucky, you cannot. So it might be worthwhile to place that piece of property in the hands of a trust. So one more word on what a revocable living trust does. You're the trustee of it during your lifetime. You're in control. It's basically moving your property from this hand to this hand. You still manage the same amount of control over those assets, any property held in the trust during your lifetime. Only at your death would it become irrevocable and pass through to your beneficiaries the way that you wish for it to go. The other thing that a revocable living trust can do is it can protect your beneficiaries from creditors, from marital claims. Because it becomes irrevocable at your death and passes through to your beneficiaries in the way that you direct, it is held in a separate trust for them. So here's a scenario. You have a child and they're married, a son-in-law or a daughter-in-law. Their marriage subsequently fails. If you had died and the money was passed through to them through a will and they commingled it in their bank account with their spouse, their marriage subsequently fails. At that time, it's commingled and the divorcing spouses would have an equitable division of that property. If your child inherits by a trust for them, for their benefit, that asset would be separate trust account for them, and if their marriage subsequently dissolved, the in-law would not have any access to that money. In the same way, maybe you have a beneficiary who is in a career that has high liability exposure, maybe in healthcare, maybe in the legal field, people who are often sued. If those assets are held in a trust for their benefit, a judgment creditor cannot access those monies. Same as if they have consumer debts. Creditors can't come calling for assets held in the trust. So for a lot of people, not only do they like to transfer assets to a trust to avoid probate, but they also like to direct the way their beneficiaries may inherit. You can put restrictions on it. A lot of the times what we see is that people, there are these 4 categories. They're called ascertainable standards: health, education, maintenance, and support. Those are kind of the standards that we place on how people can take distributions from a trust. They're all really broad categories. Health can pay health insurance, healthcare costs, surgeries, pharmaceuticals. Education can pay for everything from, private education through to college, vocational school, entrance exams, room, board, tuition, books, meal plans. Really broad categories is the point I'm trying to make. Maintenance and support are basically catch-all categories that allow your beneficiary to continue living the life they're accustomed to living. So if they have their own separate trust account, they can take anything from any amount of the principal of that trust account for those purposes. They just have to go to the trustee, ask for it. Maybe we could allow them to be their own trustee if they're responsible and an adult. In addition, once they reach a certain age, maybe we allow them to take an additional percentage each year from the principal of the trust, their respective trust, for any reason at all, something that doesn't fall into those categories. I short-changed my explanation of what was maintenance and support. Anything that allows them to continue living the life they're accustomed to living. Maybe that's taking a family vacation, but maybe it's also fixing the HVAC in their home or buying a new car. So those are broad categories. They're designed that way to give the beneficiaries a lot of access to those assets, but not completely unfettered access. Maybe you have a beneficiary who's a spendthrift and you don't want them to burn through that money. Maybe you have a beneficiary who's a minor and you don't want them to get a large sum of money at age 18. You can structure it. Maybe they get a lump sum at 25. They can use it for any of those categories: health, education, maintenance, and support up to that time. But at 25, maybe we give them a lump sum. Maybe at 30, maybe at 35. You get to choose. There's no set way. We have advice as to what works best and what doesn't, but it's ultimately up to you. So that's why a lot of people like a trust. Maybe you also have assets that can't be jointly titled. If you're single, widowed, and you don't want to own your property jointly with someone else, another reason why a trust might be right for you. Other thing is if you have assets like Alex alluded to a minute ago that aren't located in Kentucky or are in some distant location. If you have assets, say you have a cabin in Tennessee, or I met with someone the other day and we were halfway through the meeting and they remembered that they forgot to mention their condo in Gulf Shores. If I had a condo in Gulf Shores, I wouldn't have forgotten about it, but if you don't transfer that property into a trust, you would have a probate proceeding to take care of your property here. You would have to open an ancillary probate proceeding wherever that other piece of property is to transfer it out of your name there. More time consuming, more costly. You can avoid both of those by placing those assets in a trust. Now, you maintain full control of them during your lifetime, and only at your death does it direct who can take and how they do. Yeah, and I think I hit that next slide too. Okay, great. Well, Alex and I will hang around, like Janine mentioned earlier. If you have questions, if you want to talk to us privately about some of the things, we're happy to take public questions as well, if anyone has any.
And I will say, if you have to go to a meeting or have to get out of here quickly, we do have that little QR code that'll ping me. So if you have a question for Connor, you can put that in there, and then I can forward it on to him. That is there available.
I left cards at the sign-in table as well, if you'd like to.
Yeah. Well, thank you so much. We appreciate you guys.